Hello, everybody. My name is Juan Carlos Brando. Thank you for joining us today in this show with one of the attorneys in the law firm of Margaret W. Wong and Associates. And thank you so much for this day, for this opportunity to share with all of you this important information regarding to immigration. So let's welcome the attorney Nur Chamas, who is in the city of Cleveland, Ohio. Today we have the attorney Margaret W. Wong in the office in Atlanta. So I am here in Atlanta, but she's quite busy with so many clients. So she asked some of the attorneys in the city of Cleveland, in the headquarters, to help her out with the interview today. So welcome, attorney Noor. How are you doing today?
Doing well. Thank you for having me.
Thank you so much, attorney. So let's start with one of the most frequent questions that are coming right now, and it's about what's going on with the parole for people from countries like Nicaragua, Cuba, and also Venezuela, Ukraine. What is going on with all of these countries?
Well, when we talk about parole, first of all, we're talking about a discretionary type of benefit that the U.S. government can give for specific situations. It could be any situation. However, what they're doing a lot of times is they're making it easier for people to enter the country if they come from specific countries that either have some sort of conflict or some other difficulties, including economic hardships or maybe natural disasters. So right now, obviously with Ukraine, with the ongoing war, they've been trying to make it easier for Ukrainians to enter the United States and possibly, seek some sort of benefit in the United States. So many Ukrainians are able to be paroled into the U.S. And it's the same with other countries that are designated as sort of, countries of conflict. Cuba, they've been getting a lot of special treatment for a long time because of the nature of the government and the nature of the relations between the U.S. and the Cuban government. But at this point in time, it's just sort of like a discretionary availability for people from these specific countries because of the conditions in these countries. Of course, that could change at any time. The U.S. has, this is not a change in the law or anything. This is just the U.S. administration, based on policy, allowing people from specific countries to be able to enter the United States.
Okay, thank you so much, attorney. And yeah, this is something that has been very popular in the last few months about people talking about the parole, especially for Venezuelan, the humanitarian parole, and finding a sponsor. Actually, we receive a lot of calls, not from clients. We receive calls from people that are stuck in Central America that are coming from Venezuela, and they are saying, "Can you be my sponsor?"
Mhm.
So, how difficult is to become a sponsor for a parolee that is trying to make it to the United States?
Um, it's like anything else when it comes to immigration. They, in general, they're making it easier for people to come in. So the reality is that uh, it's going to be easier than normal humanitarian parole. Um, you don't necessarily need a sponsor for humanitarian parole. You need somebody to basically apply for you. So when somebody applies for you, as long as they're convinced that there is a humanitarian need for you to enter the United States, they will grant it. Now, generally speaking, these are actually difficult paroles to be granted in general. I've done several humanitarian paroles. It's very difficult for them to be granted, even from countries of conflict. But sometimes the administration just loosens it up a little bit so that people from designated countries that have serious issues, and again, one of them is Venezuela, that they make it a little bit easier if somebody petitions for you or applies for you for a parole for you to come in. it's hard for me to say how easy or how hard it is. Parole in general is not easy, but because a country like Venezuela right now is designated as a country of conflict, it makes it, they'll probably ease it up a little bit for people to come in. But everything, again, when you talk about parole, everything is on a case by case basis. So every case is adjudicated on its own. So just keep that in mind when you're doing that. If somebody does apply for parole, it doesn't necessarily mean just because they're from Venezuela that they will be granted parole. But the general policy is to make it easier right now.
Okay, thank you so much, Attorney Noor Chamas. The phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call if you want to talk to one of the attorneys in the law firm of Margaret W. Wong. 216-279-3984. 216-279-3984. Judith Offrey is asking the following question. I am on disability due to health issues, but I have two houses. Can I apply for my family? Uh, I don't actually get the question. Maybe you understand.
If the question is about petitioning for family members as family-based petition, the answer is, so you can petition. If you're a U.S. citizen and you have an immediate family member, you can petition for them. There's nothing that would preclude you from doing that. Now, when it comes for them to be able to adjust status in the United States, they will need a sponsor. So if you are their sponsor, because you're the one who's petitioned for them, you will need to file an affidavit of support. Now, if you don't have sufficient income because of your health conditions or your inability to work, then what you can do is have a joint sponsor who makes sufficient money under the rules to be able to sponsor the immigrants in this case. What you have to have is somebody who's a U.S. citizen or a lawful permanent resident and who actually resides in the United States to file a affidavit of support for these family members in order for them to be able to adjust status. But as far as petitioning for them, you can always petition for family members as long as you qualify if you're a U.S. citizen and you can prove the relationship with that family member.
Okay, thank you so much, attorney. And yeah, so in this case, let's say this person is on disability and has, let's say, a pension
Mhm.
for disability. Um, Maybe doesn't have the income that is the minimum for the the poverty level,
Right.
but she has two properties. Those properties are taken as part of the income or her profit or wealth that could take care of these other people.
Yes, you can use assets to supplement,
Oh, yeah,
and assets can be used in order to help with the sponsorship. So it can be looked at as something that can be contributed towards, sponsoring the potential immigrant. Now, with assets, it gets a little bit complicated in terms of how many assets you need, how much money you actually have. I generally try to stay away from using assets if I can, because it's more complicated. If you can get a joint sponsor, it's actually a lot easier because it's very clear cut. As long as they make the sufficient income, then they can sponsor, and so you wouldn't have any problems.
Okay, that sounds perfect. Thank you so much, Attorney Noor Chamas. And don't forget that the phone number is 216-279-3984. 216-279-3984. The next question is, hi, I am Venezuelan. I lived in Chile for 4 years, moved to the United Kingdom, and they denied my asylum in the United Kingdom. My asylum was denied. Could someone apply for me on that parole and fly me into the United States of America?
Well, someone can definitely apply for you. The question is whether it will be approved. That's a separate issue. But you can always have somebody apply for you. Then USCIS has to approve the parole before you're able to fly into the US. But if you do have a parole approved, then you will be able to come to the US and be paroled in as a parolee.
Okay, thank you so much, attorney. And yeah, this is one of the most frequent questions that we are getting right now in this kind of cases. The next question is: how I filed what of court for my daughter. It was granted one day before she turned 18. Now we did the I-360, but they sent a notice of intent of denial, saying that we need to prove why they should grant her legal status since she was already 18 when we filed the I-360.
Okay, in those situations, she should still be granted the I-360. I would have to read. I mean, this is something that's a little bit difficult for me to answer because I don't know what's actually in the request for evidence or the intent to deny that you received. So I would have to read it to figure out exactly why they're asking for that. But generally speaking, as long as the award of court case was approved, they should actually approve the I-360, even if they are now over 18 years of age.
Okay, thank you so much, attorney. Um, don't forget that the law office of the attorney Margaret W. Wong has 9 offices in the United States. One of the offices is in Atlanta, where I am located right now, and Ms. Wong is around the hallways and the offices here, just taking care of the clients. The office in Cleveland, where the attorney Noor Chamas is the headquarters of the office. Also, Chicago, Columbus, Memphis, Minneapolis, New York, Nashville, and Raleigh, North Carolina. And the phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call to talk to one of the attorneys in the law firm of the attorney Margaret W. Wong and Associates. Okay, so the next question, attorney, is about. I'm gonna try to read it because it's the way they wrote it is very difficult. Um, I live in Dayton, Ohio, and I would like your assessment because I have a felony for family violence, but I don't know if this is going to affect my case since I am applying for asylum. Uh, so basically, the question could be: does a felony for domestic violence affect an asylum application?
It could affect an asylum application if you are convicted of an aggravated felony, which is a crime. I mean, there's a list of felonies that are considered aggravated felonies under immigration law. One of them is a crime of violence that carries a sentence of a year or longer. If you are convicted of such a crime and it's an aggravated felony, then yes, you would not be eligible for asylum. Now, you could potentially still be eligible for withholding of removal or protection under the Convention Against Torture. However, even in withholding of removal, if your crime is considered a particularly serious crime by the court, then that would also make you ineligible for withholding of removal. And the only thing that you could qualify for would be something called deferral of removal under the Convention Against Torture. And just to quickly explain it, so withholding of removal is something that's similar to asylum, but it doesn't carry the same benefits as asylum. So if you are granted withholding of removal, you will be allowed to remain in the US and you will be given employment authorization. However, you would not become a lawful permanent resident at any point. So basically, you're kind of in limbo, but you can pretty much stay here indefinitely or until conditions in your country have changed. But just to summarize, if you do have an aggravated felony, you would not qualify for asylum. You may qualify for withholding of removal unless your crime is considered a particularly serious crime, and that usually involves a more thorough assessment and evaluation of the crime and the background of the crime.
Okay, thank you so much, attorney. And don't forget that the phone number is 216-279-3984, 216-279-3984. Attorney Noor Chamas in the law firm of Margaret W. Wong and Associates. The next question comes from our YouTube channel. Hi, my sister's son is 17 years old. He's coming to the U.S. for the first time. Is he qualified for DACA?
No, unfortunately, he would not qualify for DACA. In order to qualify for DACA, you had to have been in the United States since about 2007. So if he enters now, he just wouldn't qualify, unfortunately.
Yeah, there's a lot of requirements for people that can apply for DACA to meet. And one of them is being here before June 15th.
15th, yep.
June
15th, 2007.
2007. Thank you so much, attorney. The next question is, hi, I've been in the United States for 10 years, have 2 kids. My country is in trouble now more than before. Would it be convenient to file asylum now that I have 10 years and 2 kids in the U.S.?
Okay, so I'm going to answer this. It's going to be a longer answer. First of all, generally speaking, when you file for asylum, in order to qualify for asylum benefits, you had to have filed your application within 1 year of entering the United States. Now, there are exceptions to that. One of the exceptions is if there are changed country conditions. So, for example, if you enter in 2000 and you don't file for anything, then say in 2010 something happens in your country that causes you to then be afraid of returning to your country. If you then apply for asylum, then that would be an exception to the 1 year requirement because the country conditions changed at that time. Now, that, of course, that doesn't necessarily mean your application will be approved. So what will happen is if you file for asylum with the Immigration Service, if the Immigration Service does not grant your asylum application, it will not be denied, but what will happen is the case will be referred to the immigration court where you will have a second opportunity to present your asylum claim. However, once you're in immigration court, then you are allowed to file any applications that you qualify for in immigration court. So sometimes when people file for asylum, they end up in immigration court. If they qualify for something else, then they can apply for that. Now, in your case, if you've been here for over 10 years and you have 2 US citizen children, you probably would qualify for something called cancellation of removal. Under cancellation of removal, you would have to show that you've been in the US for 10 years, that you have been a person of good moral character during that time, that you have qualifying relatives, that means a spouse, a parent, or a child who are either US citizens or lawful permanent residents, and that qualifying relative would suffer exceptional and extremely unusual hardship if you had to return to your country. If you are granted cancellation of removal, then you can get a green card. But again, it's a long process, it's very involved, and it requires establishing a lot of things. So if you are thinking about doing anything like that, it is very important that you consult with an attorney first.
Okay, thank you so much, attorney. Don't forget, the phone number is 216-279-3984, 216-279-3984. What can I do if I was affected by the system? I got in prison for 6 months, and then they released me, and they said that it was just a mistake. I was accused of something really bad, and now I just want to see what I can do. I just need my immigration status. I don't want money, I don't want anything else, but they made a mistake and they put me in prison for no reason. Thank you.
Okay, so this is a hard question to answer because I'm not sure what you would qualify for in immigration. All I can say is if you had been charged with something, but ultimately you were found to either you were acquitted or you were found to not have committed that crime and you have no official conviction under that crime, or if the crime, if you were convicted but the conviction was vacated or dismissed because an error was made or your rights were violated, then you should still be able to qualify for certain immigration benefits. Again, it would be hard for me to answer this question because I don't know what you would qualify for right now or what immigration benefits you're even trying to get. But just generally speaking, as long as you no longer have a conviction, you would be able to qualify.
Okay. Thank you so much, attorney. And yeah, we're getting some interesting questions in today's show. I will just ask a question for information. We are already in January, and we know there is a date limit or a time limit for H-1B visas. So, when is a good time to start filing for H-1Bs? What is the deadline? If you have any idea already on this year.
Yes, there are deadlines to file H-1Bs. I don't do employment-based immigration in the office. I would recommend that whoever wants an answer to that question to call the office and get a consultation. I just wouldn't want to give any information that may not be accurate at this point, but we do have specialized attorneys here that do employment-based immigration, and they would be better able to handle that question.
Okay, thank you so much, attorney, for your answer. And yeah, well, maybe in the next show we are going to have an answer for you. But don't forget, you can just call, and the phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call in order to talk about immigration with one of the attorneys in the law firm of the attorney Margaret W. Wong. The next question is, my name is Shailesh. How can I get an? Okay, this is another same kind of question. Okay, my question is, do you know of any updates to the family-based green card priority dates for F2B? It looks like it has not moved in a couple years.
So that would, well, I can't say that. I have to look at the most recent visa bulletin. I don't have it in front of me right now. But whatever is in the visa bulletin, that's what priority date they're working on at that point. So if you filed your application or if your petition was filed, after that date, then you just have to wait whatever period in order for your priority date to be current. Sometimes they don't move for a while because they're just so backlogged and they have so many petitions. Sometimes they regress. Sometimes they move a little bit faster. So this is normal. It happens, but it's just based on whatever the State Department Visa Bulletin is saying at that point.
Okay, thank you so much, attorney. And well, we're gonna have one more question for today, and then we're gonna dismiss. We have a lot going on here in the office in Atlanta, so thank you so much. Okay, so I got my green card approved about a year ago. I need to go to Spain. I have an invitation there, but I don't have my passport for my from my country. They are not giving passports, and I don't know how to do to this trip. Can I go only on my green card? Because my sister went on a cruiser a couple weeks ago without a passport, and she was let in back with her green card. Is that something that I could do?
If you're absolutely not able to get a passport from your country, then what I recommend doing is getting a travel document from the US that is like a re-entry permit that you would get if you have a green card. I don't advise, even if you do have a green card, I generally don't advise traveling without any sort of travel document. You may be let into the country either way, but it's just, it's risky. So what I would suggest is that you file an I-131. It's an application for travel document or reentry permit. And once you have that with you, it's safer for you to return to the country.
Okay, perfect. Thank you so much, Attorney Noor Chamas. And I'm looking forward to see you next time and talk about immigration and many, many other things that we know that you are an expert talking about this. Thank you so much and see you next time.
Thank you for having me. I appreciate it.
Thank
Have a
you.
good day.
And don't
Thank you.
forget that you can call the office. Is the phone number 216-279-3984, 216-279-3984. Attorney Margaret W. Wong in the law firm, and also 12 attorneys besides the attorney Margaret Wong working for you and helping you in your immigration case. 216-279-3984, 216-279-3984. Thank you so much, attorney, and see you next time.
Thank you. I appreciate it.